Welcome back to part 2 of the Australia PepsiCo case, one of the most significant recent developments in international tax law. If you thought part 1 was complex, this chapter dives even deeper. We'll unpack the full federal court appeal, dissect the legal reasoning, and explore the court's nuanced approach to contractual interpretation, tax characterization, and the diverted profits tax provisions. So, let's dive into it. First, a quick refresher to frame the issue. In 2009, Pepsi entered into an exclusive bottling agreement with Schweppes Australia. Under that agreement, Schweppes was given the rights to bottle and distribute Pepsi, Mountain Dew, and Gatorade in Australia. The contract required Schweppes to purchase concentrate either from Pepsi directly or from a nominated affiliate. Pepsi nominated PBS Australia, an Australian entity which sourced the concentrate from CM Singapore, another Pepsi affiliate. CM Singapore manufactured the concentrate using a proprietary Pepsi formula. So here's the flow. Schweppes places orders with PBS Australia. PBS Australia takes payment and passes most of it to CM Singapore, less a margin, and the concentrate is delivered, but no explicit royalty is paid. Critically, the contract between the parties made no mention of a royalty for the use of Pepsi's intellectual property, despite Schweppes clearly relying on Pepsi's branding and formulas. The ATO challenged the arrangement on two fronts. First, it argued that Schweppes' payments implicitly included a royalty, even though the contract only refers to concentrate. Alternatively, if it wasn't a royalty, then the arrangement was a tax avoidance scheme, warranting the application of the diverted profits tax. The matter proceeded to the federal court, where Justice Mashinsky agreed with the Commissioner's royalty characterization, but Pepsi appealed. And that brings us to the full federal court, with Justices Perham, Jackman, and Colvin on the bench. The first issue on appeal, unsurprisingly, was whether the payments from Schweppes to PBS Australia included consideration for IP use. In their majority reasons, Justices Perham and Jackman approached the question through strict contractual interpretation. The key was, what did the contract actually provide? The judges emphasised that the payments were contractually characterised as consideration for concentrate. There was no distinct fee for the use of Pepsi's IP, nor any language that implied such a split. The Commissioner's counterpoint was that it would be commercially irrational for Pepsi to grant the IP rights for free. You'll recall from the first video that Justice Mashinsky of the Federal Court agreed with this sentiment. But here is where the full Federal Court made a crucial distinction. To quote Justices Perham and Jackman, the Commissioner's submission proceeds on the overly simplistic assumption that the grant of the license to Schweppes was only of benefit to Schweppes. In fact, it was also a benefit to Pepsi. In essence, the court recognized that the arrangement was symbiotic. Schweppes leveraged the goodwill of an established global brand, and Pepsi preserved and enhanced its brand in Australia. Further, Schweppes' use of Pepsi's trademarks was heavily restricted, tied closely to Pepsi's quality controls and global brand standards. Unlike a copyright or patent license, Schweppes was not permitted to use the trademarks for any purpose it liked. It could use the trademarks, but only for the purpose of selling the beverages, the nature of which was entirely controlled by Pepsi. Justices Perham and Jackman concluded that once the full benefits and restrictions of the arrangement is appreciated, the Commissioner's submission that Pepsi were giving away the right to use the trademarks for nothing must be rejected. The payment was for concentrate only. The second question was, did the income come home to Pepsi in the US? You'll recall that this question is important because there can be no royalty withholding tax obligation unless the payment was made to a party outside of Australia. The ATO argued that Pepsi directed Schweppes to pay PBS Australia, invoking the doctrine of payment by direction. The idea being, if Schweppes was contractually obliged to pay Pepsi only, but Pepsi asked the payment go to a third party, the funds would still be considered income derived by Pepsi. But the full federal court found that argument inapplicable. Why? Because there can be no payment by direction unless there is a prior obligation to make the payment. In this case, under the contract, Pepsi wasn't the only seller. The contract allowed a Pepsi nominee to also sell the concentrate. And because PBS was the nominated seller, Schweppes dealt directly with PBS as principal, not as agent. Further, Pepsi never held title or possession of the syrup. No debt was owed to Pepsi because the concentrate was not being sold by Pepsi. Therefore, the judges held that it is not possible that by paying PBS in Australia, Schweppes was actually paying Pepsi in the US. So the full federal court sided with Pepsi on both issues. The payments were deemed as being only for concentrate, and they did not constitute income derived by Pepsi in the US. Thus, no withholding tax obligation arose. Finally, we come to the diverted profits tax question. Even if the payments weren't royalties and didn't go to Pepsi, did Pepsi nonetheless obtain a tax benefit from a scheme designed to avoid tax? The parties agreed a scheme existed, but two further questions had to be answered. Firstly, did Pepsi obtain a tax benefit? And secondly, was the principal purpose of entering into the scheme to obtain that benefit? You may recall that to determine if a tax benefit exists, the court must identify a reasonable alternative to the scheme. It does so by asking, what would have happened if the scheme had not been entered into? The ATO proposed two alternatives. Alternative 1, Schweppes pays the same amount, but the contract expressly states that the payment is for all of the property provided by Pepsi, meaning both concentrate and IP licensing. Alternative 2, Schweppes pays the same total, but it's split into two distinct components, concentrate and royalty. But here's the catch. These alternatives must reflect commercial reality, and that's where the ATO's case faltered. The judges said that if you're going to claim the price includes a royalty, you need to carefully examine the economics of the deal. That means looking at how much it costs Pepsi to make the concentrate and what other benefits and obligations come with the agreement. Only then can you say whether the price also covers the value of a license. But in this case, the ATO didn't provide any evidence showing that the price for the concentrate actually included a royalty. If it had, then it would be fair to assume that without the scheme, Pepsi would have tried to get that royalty in some other way, either as part of the concentrate price, like the first alternative, or as a separate royalty, like the second alternative. But without that, both alternatives were merely speculative. So the full federal court concluded that the actual scheme's commercial substance was consistent with a straightforward sale of concentrate. And given that there is no reasonable alternative to the scheme, it was concluded that Pepsi did not obtain a tax benefit in connection with the scheme. Next, the court considered whether the scheme had a dominant purpose of obtaining a tax benefit. To answer this question, the court must weigh multiple factors to infer the purpose objectively. That means that the court isn't concerned with the taxpayer's actual personal motives, only what a reasonable person would conclude based on the factors in the legislation. 4 of the 8 factors favoured the commissioner. These were form versus substance, change in financial position, impact on foreign tax liability, and the estimated quantum of tax avoided. However, each factor was ultimately undermined by a lack of reliable evidence on the royalty component. For example, the ATO suggested that one of the factors, being Pepsi's financial position, changed as a result of not receiving the royalty, which the court, in theory, agreed with. But without identifying a quantifiable royalty, the materiality of this change was unclear. Ultimately, the court held that while a tax purpose may have been present, the failure to establish a reasonable postulate meant the commissioner's case could not succeed. So the appeal was a smashing success for Pepsi. But as Lenny Kravitz famously put it ain't over till it's over. And in November 2024, the ATO was granted special leave to appeal the case to the High Court of Australia. The case was heard in April 2025, with the final decision still pending. But before we analyse that, some final thoughts on the full federal court's decision. This appeal underscores how contractual drafting and legal form are still central to judicial reasoning, even in the face of economic substance arguments. The key takeaway for practitioners is that IP rights must be clearly defined in intercompany contracts. Economic substance needs to be substantiated with robust evidence. Courts will scrutinise assumptions and require commercial plausibility. And attempts to invoke Australia's anti-avoidance provisions require a strong alternative grounded in commercial reality. Pepsi's win at the full federal court is a reminder that a tax law, especially in the cross-border context, is a balance of legal form and economic substance. As always, if you enjoyed this video, let me know. If you have any feedback or suggestions, I would love to hear them so that I can continue to make these interesting and engaging. I'll see you in part 3 to analyse the High Court appeal.